Welcome to our DEI SIG meeting with our very own Kathy Harper, who is going to be talking about Title IX, California style, because I know many of you might have watched it was the Washington DEI on Title IX. And then this is an update from Kathy. But I can't I can't say enough about Kathy, and she is so good that I'm going to turn it over to her right now. Kathy, thank you. Thank you.
Thank you, Kathy, for inviting me and giving me an opportunity to make this presentation. I had put this together for our Morgan Hill branch. Actually, it was there's a couple of branches up there. I'm trying to think of I don't know, my brain's gone. Um, and I did it about 6 months ago. And Kathy told me she was interested in Title IX. I said, well, I just happen to have this presentation. I'd love to do it for the online branch. So that's what you're going to get with a lot of updates, because as you know, things have been moving very quickly since January of this year, and they're changing almost every day. So I think what you're about to see is about as updated as you're going to get. I finalized it, did some tweaks to it just on Saturday. So because we're a small group, which is nice in some ways, feel free to interrupt me, ask questions. Usually I save the questions for the end, but I'm happy to take questions as they come up. And we could just kind of have an informal discussion around this. Just as a prelude, I'm going to go through in the beginning. I'm just going to do kind of a review of Title IX, because I think it's always good for some members who don't keep on top of it and aren't really tuned into everything that Title IX is about and what it's designed to do. So I'm just going to do a little bit of review, and then I'm going to talk about some comparisons between what I really want this to be a focus on is all this stuff that's coming out of Washington, D.C. since January. How does it affect us here in California? Because we're fairly unique. We're not the only state that has good protective laws, but ours are the best and the strongest. And so the question that always comes up is, well, what happens when those collide? We're looking at that in another context as well, as far as the school board project. The same issue has come up. What happens when we get all of these rules and executive orders and laws and changes that are coming out of Washington that are in conflict with our state laws? So this is a subject that I've been really, because I'm the chair of the school board project, I've been really trying to keep on top of this for quite some time, well, ever since January. So these are some really, really important things that we need to be aware of, and understanding how they affect us, and then how does it affect us here in AUW? Because Title IX is such an important part of the work that we do, and we were actually very involved in it from its inception. So with all that intro, I'm going to go ahead and start sharing my screen. And we'll go through. This always happens. There we go. I have a little box up at the top that always covers up my ability to, and you can see that if you're looking at on the right.
Kathy, can this slide presentation be available to all of us later?
I'm going to post it on the public policy web page on the California Online.
Thank you.
Okay. So, and if you're seeing on the right, if you're seeing all the participants, it's going to cover some of the slideshow. So you might want to click on hide thumbnail view so you can see what's going on. Okay, so this is what we're talking about. Where are we now in 2025? And as I said, we're going to cover a little bit of the history and overview, and then we're going to look at a chart of the changes from the Trump to the Biden administration and back. Because what I think most of us understand is that we had all these changes under Trump 1 in 2020 when Betsy DeVos came in. And then when Biden came in 2016 through 2020. Then when Biden came in 2020, made some very significant changes, but unfortunately they didn't go into effect until very late, toward the very end of his term in 2024. And then Trump comes in again, Trump 2, and then we go back to the original. So I think it's instructive to look at those changes in terms of what did we have before Trump? What did we have after Trump? How did Biden change those in a very positive way? And now what's happened when we've actually gone back to what we had? And then we're going to end up talking about the future challenges, as I said, because of all the stuff that's coming out of Washington, D.C. That's very challenging to us here in California. And we're going to look at those challenges. So we'll start with a little bit of an overview. What is Title IX? It's Title IX of the Education Amendments Act of 1972. It's federal legislation passed by Congress, and this is really important to keep in mind. We're going to talk about this later. The roles of each of the branches of government and how they affect and can potentially affect what happens with Title IX. But originally, it came out of a law in 1972. Joe Biden was a senator there, and he was actually the senator who carried the bill to enact Title IX. And this was an amendment to the education codes. The purpose of it was to ensure equal opportunity in education for all students, from kindergarten through postgraduate, as well as employees. So it doesn't apply just to students. And it isn't just about athletics. I did a whole presentation many years ago about how there's a misconception that Title IX is just about athletics, and it's not. It applies in a lot of different ways. So it's to ensure equal opportunity in education of students as well as employees. That's the first part. Second part is of educational institutions who receive federal money. This is another really important thing to keep in mind, that we're talking about institutions who receive federal money. That's why that's the leverage that the feds have to affect what happens at the state level. Because where state institutions accept federal money, federal feds have a say. And then the final piece is regardless of sex. And of course, that's the most important part for our purposes. So what does it say? Here's the actual language of the amendment. No person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. So now, there was a time when subjected to discrimination was pretty well understood. It was not particularly controversial. Discrimination was discrimination. It applied primarily to certain classes of groups, and those were groups who had been underrepresented historically. Under the new rules, we're going to see that the whole concept of discrimination has changed and is changing and is taking on a whole new and meaning in a direction that is not the right direction as far as AUW is concerned. So what does it do? It's a Title IX and related regulations, and this is important because that's all Title IX says. This is, all it says is that no person shall on the basis of sex be excluded from participation in or be denied the benefits of or be subjected to discrimination. That's an amendment to the education code. So this is guiding language, because under any code section, within the whole realm of federal regulations. There are rules and regulations that are put together that use this language as its basis. So it's those rules and regulations that really give us the guidance, that is states and institutions receiving federal money, give them the guidance of what they can and can't do. So this is really important. It's Title IX and its related regulations. They provide guidelines, procedures, and tools for preventing and addressing inequities that can hinder students and employees' ability to succeed in school and beyond. Why do we need it? Because it prohibits hostile, threatened, and discriminatory behavior. By doing this, it protects the rights of all students so that all students can learn, have a healthy environment in which to learn. It's also important to keep in mind, and I like to remind members of this and basically anyone I talk to who might be in a position to have to defend Title IX against those who might have a different viewpoint, a more conservative viewpoint. It's important to remind them these advantages extend beyond individual students to the nation itself, because the whole nation stands to gain when we have a well-prepared workforce in which the brightest minds are allowed to advance. If you didn't have an opportunity to sit in on the Washington presentation a couple months ago that came from the Washington online branch, one of the things that was really interesting to me about that was I went through a little bit of the history, and one of the presenters on the panel talked about the fact that that the whole idea of women in the workforce, it was never the rules that came out that directed that whole concept weren't really about giving women more opportunities in education for education itself, in and of itself. It was always for some other purpose. So women were allowed into the workforce, for example, during World War II, because it helped the nation progress. And so in order to have the skills to provide, to complete some of those jobs, they had to be educated. Women have to be educated so that they can help educate their children. Those kinds of things. It was always about women needed to be educated so that they could serve some other purpose, never for the purpose of just educating, being educated themselves.
Kathy, you said could you go back, please?
Yep.
So how does the by prohibiting hostile, etc., apply then to transgender, queer, the LGBT continuum?
So we're going to talk a lot about that as the slides go on, and that's one of the most important areas that we need to look at as we think about, if we look at the changes that have taken place from one administration to the next and then back again. We're gonna spend a lot of time on that, Toby. So if you could just hold that thought, I'm definitely going to get to it. Okay. Yes.
Okay.
Okay. Okay, so who benefits from Title IX? This is another misconception, especially I think among a lot of AUW members, that because our focus, of course, is on advancing opportunities for girls and women, we forget that Title IX is it benefits all across the spectrum, girls and women, and boys and men. Title IX offers no special benefits or advantages for girls and women. It just says no discrimination on the basis of sex, period. It's gender neutral, and it's designed to ensure equality in education for all students by eliminating any form of sex discrimination. So this is an important question. Why do we, when I say we, the we is us here in AUW, why do we care about Title IX so much? So it fits with two of the pillars of our public policy priorities. The first one is AUW advocates to ensure equal access to quality public education for all students. And one of the main points of that public policy priority is vigorous enforcement of Title IX. Now, note here, if you hadn't noticed, if you haven't taken a look at our new public policy priorities, up until this year, the language of that bullet point within equal access to quality public education pillar has just simply said vigorous enforcement of Title IX. We actually changed that language this year because the Title IX that exists now under Trump 2 is not necessarily an enforcement that we want to advocate advocate for. So we added this language of vigorous enforcement of Title IX protective provisions, because as we're going to see in a few minutes as we go through the actual language, there's still a lot of protective provisions in there. They're being redefined by Trump 2 in ways, as I said, that are not consistent with our values, but those protective provisions that still exist, we are still very, very much, very strongly in favor of, and we still believe in advocating for those protective provisions. So that's something that I know a lot of our members may have noticed in the new public policy priorities that came out this year. So take a look at that and think about that, why we added that language. The other pillar is our social justice pillar, and that's that we advocate for social and racial justice for all members of society, including from violence in all its forms. Title IX has a very, very strong component regarding sexual harassment and sexual violence on campus. So this fits right into our public policy priority of advocating for freedom from violence in all its forms. We also a bullet point within this pillar is our guarantee. We advocate for a guarantee of civil and constitutional rights for all, including all forms of gender identity and expression and all family structures. And Toby, this goes directly to your question about how does Title IX affecting what's going on within our LGBTQ plus, including our transgender community of students. So these are the reasons why AW is so involved in this and why we care so much about what happens with Title IX. Okay, so let's go ahead and take a look at the kind of the evolution since 2017 when Trump came to power in his first term. So the evolution from 2017 to the current day, what's happened. So in 2017, as we know, Trump was elected as president. At that time, he appointed Betsy DeVos as education secretary, and she immediately went to work on Title IX and made some very important changes. And two of the most significant ones that we're going to be looking at more closely had to do with the manner in which sexual assault allegations were investigated on campus. This goes primarily to secondary education, to college campuses. It also affects, to a lesser degree, what happens at the lower grades, but primarily what we were concerned with is investigations on college campuses. And also with regard to including gender identity within the meaning of gender protections, those protections were removed in 2020. In 2024, when Joe Biden is elected, he immediately sought to make changes to what had happened in the previous administration to go back and strengthen and go back to the original protections in Title IX. So this is a process, again, something everyone may not be aware of, but when new rules and regulations are being proposed by a federal agency, they have to open up hearings and they have to give the public an opportunity to comment on the proposed changes. And then then they take a look at those proposed changes, and they may or may not adopt all or any of them, but they have to give the public an opportunity to comment. So what we saw in 2024 was that when Biden finally opened up the hearings to the public, there were over 240,000 responses. And I will say a lot of those came from AUW members to comment on the changes that were being proposed. So all of this takes place over a year or so. And finally, in April of 2024, the new guidelines were adopted, and they were set to become effective as of August 1st, as I said, almost near the very end of his term. And those changes involved rules related to sex-based harassment, anti-LGBTQ plus discrimination, and discrimination against pregnant and parenting students. And these were really significant changes that needed to be addressed, that had been weakened under the Trump 1 and DeVos rules. So they were great rules. The one thing that did not come out that the new rules did not address was transgender students in athletics. And he purposely left that conversation out with the idea that in his second term, which he was contemplating at the time, that he would address those and flesh them out more fully. But they were not part of the original discussion or proposed changes in 2024. So what happened? No sooner had these finally become effective as of August 1st, and immediately there were challenges, and there were lawsuits that were brought and by many states challenging the new rules. I'm going to go over the changes between the two rules in a minute, but I just wanted to interrupt to just let you know that as things progressed, here was the progression. So in January of 2025, just before Trump was inaugurated, this is very early in January, in a case called Tennessee versus Cordona, a federal appeals court in Kentucky issued this ruling. And it said that the Biden rules were, quote, fatally tainted by legal shortcomings, and that the Education Department had overstepped its authority by expanding the scope of Title IX. The judge said there's nothing in the 1972 law suggesting that it should cover any more than it has since Congress created it, which in and of itself, just as a side note, was pretty bogus, because between 1972 and 2024, there had been a lot of changes and amendments to the rule. But the court said that it should stay the same as it was from 1972. He said the new rules was an attempt to bypass the legislative process and completely transform Title IX. He also found that it violated free speech rights because, in his interpretation, he said it required teachers to use pronouns aligning with a student's gender identity. So the upshot of this was that as soon as Trump took over again on January 22nd of 2025, immediately announced that pursuant to this law, to this ruling, everything was back to the 2020 rules. All right, so what does that mean then, again, as we look at this evolution? So I'm going to address this in the three different segments. We're going to look at sex-based harassment. We're going to look at discrimination involving LGBTQ plus students, and then how it affects pregnant and parenting students. Those are the three important ones. So the original Trump rule was that if we look at sex-based harassment, we're going to look at, first of all, a duty to address. So the Trump rule is that the campus investigators and campus personnel had to address a complaint of sex-based harassment if it was so severe and pervasive that it effectively denies a person of equal access to a particular activity. The Biden rule changed that to make it less burdensome on the complaining party, which was almost always a female. Could, of course, be a male, but in most circumstances was a female complaining about sexual harassment, sex-based harassment. And so the Biden rule was that the complaint had to show conduct that was so severe or pervasive, not both, as under the Biden rule. and so severe or pervasive that it denies or limits a person's ability to participate. So a little bit of a softening, a lessening of the burden on the complaining person. So that's gone now, and we're back to the original rule that the complaint must allege conduct that is so severe and pervasive that it only denies, not limits. And then it addresses the standard of care for the university, college campus. Says the Biden rule, the original Trump rule was that the campus must respond in a way that is not deliberately indifferent. Very, very low bar for the response of the campus leadership. Deliberately indifferent is all they had to show. The Biden rule was much stronger. It said that they must respond with prompt and effective action. That was a standard that they would be held to. Did they reply promptly? And did they take action that was effective in addressing the complaint of the alleged victim of the sexual harassment? So that's gone, and we're back to a very, very low bar of all the campus has to prove is that they were not deliberately indifferent to the complainant. Also under sex-based harassment, it addressed the second part was the way that the investigation, and this is one of the most important ones. This is one that a lot of you may be familiar with, and that a lot of our members were very much in arms up in arms about in 2020 after the DeVos rules came out. And that is that it changed the way that the investigation is conducted. The Trump rule under DeVos was that IHE is institution of higher education, that they must allow the parties' advisors to conduct cross-examination at a live hearing. This was just a horrible, horrible rule. It was so invasive of sexual harassment and sexual violence complaints because it meant that they would have to address the person that they were accusing, their abuser, at a live hearing and be subjected to cross-examination by that person, by that assailant or their advisor or even their attorney. These are rules that are commonplace in a court of criminal law because of the Fifth Amendment right to cross-examine your accuser. But on campus, it's a very different arena. It's a very different atmosphere, very different kind of hearing. And for a student to have to confront somebody who might be a fellow student that she would see in class every day or around campus every day, the result of this was that it had a strong chilling effect on victims being willing to come forward, because knowing that they would have to confront the person they were accusing, be subject to cross-examination by them. A lot of students, a lot of our female students just said, no, I don't want to be subjected to that, and they would just stop making complaints. The Biden administration recognized this, and that was one of the first things that they addressed in making changes. And it provided instead that the interview, that each party, and it required that the investigative arm would interview each party and witness separately in individual meetings. And then a decision maker, whoever the decision makers were in the investigative process, would interview all parties and witnesses at a live hearing, but the questioning would come from this decision maker, not from the accused person themselves. And then the school had the option of allowing cross-examination. It wasn't mandatory. It was just rather designed to be just a listening process of you each get an opportunity to state your case, and the decision maker would listen. Much more, I don't want to say friendly, because it's supposed to be a neutral proceeding, but certainly making the whole process much easier and more comfortable for complainants to feel free in coming forward. The clear implication of the changes from DeVos, and she even stated this in a lot of the literature leading up to the actual rule, was that there was a feeling that the whole procedure was unfair to the accused, that so many of these young men with promising athletic careers, for instance, were being falsely accused of sexual harassment that would haunt them forever, could get them kicked out of school, could ruin their scholarships. This was very clearly the whole intention of making this rule change. And the victim was secondary. The emphasis was on the accused and protecting the accused, whereas under the Biden rules, the shift was very clearly in favor of making victims feel more comfortable in bringing charges and coming forward and making sure that she had an opportunity for a fair hearing. So that is now all out. We have gone back to the 2020 rule, where all of the proceedings will be conducted with the accused having the opportunity to cross-examine the accuser. And then there is also change with regard to the rights to appeal. Under the Trump rule, the parties can appeal only on very limited basis, whereas under the Biden rule, the requirement was that the parties must have the same appeal rights that are afforded to all discrimination complaints, whatever the basis of the discrimination is. If it's in whatever the standard that's used in those discriminations hearings for appeals, which should be afforded to sexual harassment victims, and that rule is out, and that's gone back to the original Trump rule. Then in the area still, this is the last area under sex-based harassment. This third aspect has to do with prevention. And under the Trump rules, there are no rules or regulations whatsoever regarding training for prevention. That is, training of personnel on college campuses for ensuring prevention or assuring prevention. No provisions for training, no monitoring of barriers to reporting. So the Biden rules attempted to address both of those. There was a requirement that all employees had to be trained on the recognition and reporting, and then additional training for Title IX officials. And then with regard to monitoring of barriers, that the requirement under the Biden rules was that the campus must actively prevent discrimination and monitor and address barriers to reporting. All of those rules are out now. We've gone back to the original 2020 rules of no requirements for any kind of training. So that's all the sex-based harassment changes. Now onto the anti-LGBTQ plus discrimination rules. So under Trump 1 and now Trump 2 as well, there was no definition at all. It just simply was not addressed. There was no definition of anti-LGBTQ plus discrimination. It was not included. There was no definition. So again, if you think back to that original definition that I gave you, or the language of the rule itself, it says no discrimination based on sex, but it never defined specifically what that meant by sex discrimination. So the Biden rule attempted to address that by specifically stating that sex discrimination includes discrimination based on sexual orientation, gender identity, sex characteristics, including intersex traits, as well as sex stereotypes. And the rule required that schools must address any allegation of discrimination from any student based on any of these characteristics. That is all gone now. There is no requirement that the school has to address any sex discrimination claims based on these traits. We've gone back to no definition. So the best thing I can tell you is, as of this moment, there is no substitute, at least. There is no existing amendment that says sex discrimination is limited and it specifically excludes any of these characteristics. But we've gone back to where we were with no definition at all, that it just simply was not addressed. We're going to come back to this in a minute because it's still very, very relevant. And there are a lot of issues around what's coming out of Washington. But again, I just want to emphasize that as of today, this moment, there's no substitute definition. There was no, as far as transgender inclusion, that was not addressed. It just simply was not addressed at all in the original Trump rules. Under Biden, attempted to again address that by saying schools must allow individuals to participate in classes and activities, use bathrooms and locker rooms, and dress and groom themselves consistent with their gender identity. So very conscientious about the discrimination and prejudice that existed toward transgender students on campuses. All of this applies not just to college campuses, but of course K through 12 as well. And so this was the first time we actually had, under both of these two boxes here, this is the first time we had any rules coming out of or related to Title IX that specifically, very specifically, addressed these prejudices against transgender students, all LGBTQ students, but specifically, very specifically, transgender students, especially under this second box. So all of this is out. These students no longer, under federal rules, no longer are deserving of any specific protection. It simply, as of this moment, simply is not addressed. And then the third area has to do with discrimination against pregnant and parenting students. A couple of changes, one under Trump, one in Trump 2. The rule was that schools cannot discriminate against students based on pregnancy or related conditions, including childbirth, termination of a pregnancy, and recovery from any of these conditions. The Biden rule changed that, just not a lot, but a little bit, enough to be take notice of, and said that cannot discriminate against students based on past, current, or potential pregnancy, or any of the related conditions. And it also added lactation and medical conditions to the list of included conditions. So students could not be discriminated against in a variety of ways within the classroom setting. For instance, if they needed to be excused for lactation purposes, if there were any other kinds of medical conditions that might come up that weren't specifically enumerated in Trump 1, those could be included in the Biden rule. That's all out. So there's no longer specific protections for these conditions. There was, as far as notice of rights, these were rights to pregnant students. This was not addressed in Trump 1. Biden tried to remedy that by saying that any employee who knows of a student's pregnancy or related conditions must give them contact information for their Title IX coordinator, who would inform them of their rights. That requirement no longer exists under now under Trump 2. So just before I move on to the challenges, so that's just kind of an overview of the main areas that we're concerned about, that are related to our values and the things that we feel should be being addressed on campuses, where we were, where we progressed to, and now where we've gone back and regressed to. So what does that mean now, at the point that we find ourselves in? And we have current challenges that fall under all three of our branches of federal government, both the legislative, the executive, and the judiciary. And just a little primer on how these three are different as it relates to Title IX. The executive branch oversees the Department of Education. So the department comes directly under the president's purview. It's part of the executive branch. The Department of Education, through the executive through the Department of Education, directs and approves any proposed regulatory changes to any of its programs, which includes Title IX. The legislative branch is responsible for passing, amending, and repealing laws. And the legislative branch has the authority, is charged with granting regulatory authority to the respective departments. And then the judiciary, of course, ensures whatever regulations, whatever laws, whatever amendments has been passed by either the executive branch or the legislative branch, the judiciary has the responsibility to ensure that those proposed changes comply with the U.S. Constitution. So now we're going to break that down and look at what's going on in each of those arenas and how they're affecting what the things that we care about. So immediately, as I said, immediately on January 20th, the day he was sworn in, President Trump issued an executive order, which he titled, ironically, Defending Women from Gender Ideology Extremism and Restoring Biological Truth to the Federal Government. So, oops, I need to do that. So, a brief word about executive orders. This is really important to understand. Executive orders are not the law. The only thing that an executive order does and can do is direct a branch of the executive department, the executive authority of the presidency. All of the different departments that come under the executive branch are subject to orders from the president. So the president can order a department. I want you to investigate this. I want you to look at this. I want you to make changes that are in line with my philosophy or my agenda, whatever is within the authority of the president to change. So he issues this executive order primarily to the Department of Education. And within that order, he states that it is the policy of the federal government to recognize only two sexes, male and female. In the executive order, he sets forth his definition of sex. Now, when I say his, of course, we all know that there are a lot of forces that are at work on shaping this administration's policies, primarily Project 2025. Hopefully you're all familiar with that. And if you're not, go to AEW California. We have had an excellent presentation from our two co-chairs of public policy who did a beautiful overview of Project 2025 and how it affects all of us in AEW. So as a result of all that, this executive order comes out. It sets forth the definition of sex, gender ideology, and gender identity that the executive branch plans to change, and basically ordering all departments, not just the education department, but all departments under the purview of the executive to change its policies in line with these definitions. And finally, it states that each agency and all federal employees shall enforce laws governing sex-based rights, protections, and opportunities and accommodations to protect men and women as biologically distinct sexes. So all of the upshot of all of this is that in the executive's view, your sex is what you were born with, that no person, no doctor, no medical professional, no family member, no one has a right basically to, that's what I'm trying to think of, to deviate from these definitions that are coming out from the President of the United States, that you don't have a right to make your own choices about your body, your identity, whatever you were born with at birth, that's all that exists, period. But again, keep in mind, these orders only go to the different departments that fall within the executive branch. He follows this up with, in February of 2025, under his orders out of the Department of Education, comes this thing called the Dear Colleague letter that went to all public schools, and it threatened to withhold federal funding to schools that didn't eliminate race-based program, as well as a subsequent letter requiring districts to certify that they do not incorporate DEI in their schools. So how does that affect Title IX? Because Title IX, of course, deals with racial discrimination as well as sexual discrimination. But DEI, a significant part of DEI, the inclusion part of DEI is making sure that we include opportunities for our LGBTQ and our transgender students to have full opportunities, educational opportunities, along with all of their fellow students. So DEI is a big part of Title IX. So we'll come back. I'm going to come back to where we are with regard to the executive. I want to go through each of the three branches first, but I just keep in mind, if you're thinking about what happened to the Dear Colleague letter, I'm going to come back to that. But those are the two main things that came out of the executive right away. The legislative, so I want to go back. I'm talking about challenges, right? So these things definitely present challenges, because look at right here. Remember when I was telling you about the definition of Title IX? I said, keep in mind that the way that it affects states is because it applies to any institution that receives federal funding. So that's what our challenge, the challenges that we're facing now, is all of our schools in every state receives a significant amount of federal funding. So they're all affected by these executive orders. Those are the challenges because of the funding aspect. So what about legislative? So the challenges, the potential challenges from the legislative branch, here are some of the things that could happen. They could repeal Title IX in its entirety. Again, going back to the beginning, why I wanted to go through that little bit of history is because it's important for us to keep in mind that Title IX was created by the legislature, not by the executive. It was created by the legislature. The legislature can eliminate it the same way that they created it. So they could create it in its entirety. They could amend it to add a definition of sex to deliberately preclude sexual orientation and gender identity. They could pass laws. Sorry, my mouse is going all over the place here. They could pass laws to curtail the authority of the Department of Education, or they could adopt the recommendations proposed by Project 2025. All of these things are important and very, very possible, very strong potential right now, because we have a Republican majority. And I'm not saying this on a partisan basis, I'm just stating this factually. We have a Republican majority who are have shown a very strong inclination to basically do whatever President Trump tells them to do. So these things, because of the language that has come out of the executive, it follows very logically that the legislative is going to try to line up with those priorities, and these things become very real possibility. So they could adopt the recommendations proposed by Project 25, and one of those proposals was to dismantle the U.S. Department of Education. So how did they respond? They introduced a bill in January of 2025 saying the Department of Education shall terminate on December 31st, 2026. There was a bill out of the Senate to do that, SB 1148, and a bill out of the House to do that, HR 899. Both of those have been sent to committee. Both of those bills are sitting in committee. They have not been acted on or come out of committee, but they're still both very much alive and sitting in committee. So that's one thing that could happen. If that happens, Title IX basically is out the window because it is an animal of the U.S. Department of Education. They could also enact legislation requiring schools to refer to students by the names on their birth certificates and use pronouns with their sex assigned at birth. Both of these are contemplated within H.R. 5. That actually passed the House last year, but when it went to the Senate, they didn't act on it. And so it just died of natural causes from inaction. But it's important for us to keep in mind that this is something on the minds of a lot of members of the House of Representatives, and the possibility that they will take it up again is very real. One teeny tiny little piece of good news in all of this. It's always nice to acknowledge when we have good news. There is a piece of counter legislation. This is House of Representatives Bill number 15. This was just, oops. Why did I say 2026? That was just introduced. There I go again. Introduced in April of 2025. That was a little typo there. Sorry about that. I'll change that before this gets posted. This act makes explicit that existing federal statutes prohibiting sex discrimination in employment, including in access to benefits, healthcare, housing, education, and jury service, also prohibit sexual orientation and gender identity discrimination. So if this bill were passed, it would kind of reverse all of the stuff that's been coming out of the executive and Republican-led legislative branch legislation. Anybody want to make a guess as to how far this bill will go? It has not been introduced on the floor. It's just simply a proposal, and we'll see what happens to it. But at least we know that we have legislators who are working on this and actively trying to make changes. All right, so what about our judiciary? Very, very important. We're getting lots of wins. You may be following. We're getting lots of wins out of the federal courts. At almost in every state, every plaintiff that has brought a challenge to these federal laws and attempts to make changes, they've all been challenged, and those challenges have been met with success in the federal court. However, they will all end up eventually with the Supreme Court, with SCOTUS, the Supreme Court of the United States. And we've got a pretty good idea, I think, of how things are going there. Not well. But there have been but we have had some good wins. We've had, so I put the Mahmoud versus Taylor case in here. This just came out in June of this year. So the government cannot condition the benefit of free public education or parents' acceptance of instruction that poses a very real threat of undermining the religious beliefs and practices that the parents wish to instill in their children. This is an important case. It's not a Title IX case per se, but it's important for us to be aware of it and keep it in mind as we go forward, because it's based on parental rights, number one, and religious beliefs, number two. And it kind of foretells, this was a Supreme Court case, and it gives us an idea of where their thinking is. And we can certainly assume that there will be challenges based on LGBTQ issues that conflict with religious beliefs of parents. And so this could be a forerunner to future challenges. But on the other side, we've had 3 different federal courts find that the Dear Colleague letter that I referenced earlier actually violates the Constitution. So those proceedings are all on hold right now. Maryland found that the letter violated the decision-making procedures under the Administrative Procedure Act. In other words, that they didn't comply, that the Dear Colleague letter did not comply with required procedures. In Washington, D.C., they found that the anti-DEI policy outlined in the Dear Colleague letter is unconstitutionally vague. And in New Hampshire, a court issued an injunction stating an injunction that what that means is that it's an order to this federal government against enforcing the requirements of the Dear Colleague letter, because it said the actions raise the specter of a public witch hunt that will sow fear and doubt among teachers. Indeed, it will and has. So again, back to SCOTUS, just recently in August, they ruled that the administration can go forward with withholding grant research money from higher education institutions on their claim that DEI equals discrimination. So this is what I was talking about before when I said this administration has kind of have turned the whole idea of discrimination on its head. And it's now saying that anything that discriminates basically against white males, without using that exact language, but that's really the upshot of it. Anything that favors women or girls or LGBTQ students is de facto discrimination against white straight males. That's pretty much what their claims of discrimination come down to. And SCOTUS has given them the go-ahead to use that argument in allowing it to withhold grant research. Again, not directly a Title IX issue, but something very closely related and language that kind of can give us an idea of where this court's going in the future with what this administration's trying to do. Okay, the last segment, we're getting close to 8. I want to wrap this up. I only have 2 more slides, but this is a really important part. So right now we're very lucky in California. We have very good protective laws, and these are some of the California state protections that relate to Title IX, the old Title IX protections. In July of 2024, Governor Newsom signed Assembly Bill 1955, known as the Support Academic Futures and Equality for Today's Youth, or the SAFETY Act. It became effective January of this year. It does a lot of things, but one of the main things that I wanted to highlight that it prohibits forced outing and retaliation for refusing to out. So in other words, there are laws. One of the things the federal government's trying to do under the guise of parental rights is require teachers to let parents know when a transgendered student has confided to them, or any LGBTQ student has confided to them. And this bill prohibits that specifically, and prohibits retaliation against a teacher who refuses to do that. Evidence codes, these are all California evidence code sections I have here. 220 says no person shall be subjected to discrimination on the basis of gender identity, gender expression, sexual orientation in any program or activity conducted by an educational institution that receives or benefits from state financial assistance. Now, the state can't include federal assistance in that, because only the feds can control federal financial assistance. But at least they're protected from institutions receiving state financial assistance. 210.7 defines gender as meaning sex. It includes a person's gender identity and gender expression. Gender expression means a person's gender-related appearance and behavior, whether or not stereotypically associated with the person's assigned sex at birth. It defines sexual orientation. It means heterosexuality, homosexuality, or bisexuality. And finally, 221.5 says a pupil shall be permitted to participate in sex-segregated school programs and activities, including athletic teams and competitions, and use facilities consistent with his or her gender identity, irrespective of the gender listed in the pupil's records. So, yay us, yay California, our students have these great protections. But on the other hand, we have this stuff coming out of DC that says any institution in any state, anywhere that receives federal funds is subject to federal guidelines. So what happens when we now have federal guidelines versus state protections. One thing that's really important to remember is that Title IX is a floor. It's not a ceiling. So what do I mean by that? It means that Title IX says this is the basis of what you can and can't do. If it's not directly addressed in Title IX, if it's not specifically prohibited, that means the state can do more. It can't do less than is required of the federal guidelines, but it can do more unless it's specifically prohibited. So going back to that slide, if you recall, where I showed the comparisons, if you remember, I said that the Title IX guidelines under Trump 1 and now Trump 2 do not define sex discrimination so far. They haven't yet amended it to define sex or gender as assigned at birth, or to prohibit. There's nothing in Title IX right now that prohibits any of these things. All we have is this executive order and dear colleague letter from Trump, certainly saying what his philosophy is or his theory of governance is, but it's not been written into Title IX. So since it's not specifically prohibited by the feds, it's not prohibited by the state so far. So I guess it's pretty much what I said here. Unless specifically prohibited in Title IX regulations, they may provide more protections, but not less. But having said that, we can't lose sight of the fact these protections could be lost if the legislature amends Title IX to preclude these special protections as somehow discriminatory. They could be lost if the executive branch devises new regulations and actually amends Title IX or writes regulations into Title IX, specifically defining sex discrimination to include gender identity. Now, whenever there's amendments or any change to regulations in any federal policies, those have to go to the Federal Registry. And the Federal Registry is where anyone can go and find what any of the actual rules are. The Federal Registry used to, in compliance with the Biden rules, the Federal Registry did include gender identity as being a form of sex discrimination. That definition has now been rescinded. I just looked it up recently, and in the Federal Registry, it says specifically this rule has been rescinded. It hasn't been replaced with anything else, but the Biden rule of using gender identity as a form of sex discrimination has been rescinded. So again, that's something that kind of foreshadows what's going to happen in the future. And our California protections could be lost if the Supreme Court ultimately finds that California protections discriminate by singling out certain classes that are not specifically protected by the 14th Amendment. And gender identity is not specifically in the 14th Amendment, just like protections for abortion were not protected specifically stated in the 14th Amendment. So again, that kind of foreshadows where the Supreme Court might go with this kind of a challenge. So at any level, legislative, executive, or judicial, California could, and I anticipate will be challenged. And if any of these things happen, we could lose our protections. So the bottom line is, and here's some references that I used, and those will be posted online. So I'm going to stop sharing. And if you want to stick with me for a few minutes, it's 8 o'clock. Oh, it's a few minutes after 8. I'm happy to stay on and answer questions. It's a lot of stuff, I know.
Kathy, I'd like to thank you for your very comprehensive presentation. You are, I can't think of the word. We're so lucky to have you.
Oh, thanks, Toby. It's always my pleasure to share wherever I can. Kathy F., are you trying to say something there? Because you're muted. You're still muted.
There
There you
we
go.
go. If you are all like me, I'm devastated by everything that Kathy has brought up. I cannot believe, and I'm so frustrated that there is so little we can do to change the course of where this administration is going to. And Kathy, yes, thank you so much. This was so thorough. Even though it was devastating, we needed to hear it. And I hope many other people will watch this recording and understand where we're going with all of this. But we need to have hope that things will turn around. That's all I can say. We need hope. Okay.
Hope is nice. I will share with you from my perspective as an attorney. I'm more concerned with SCOTUS than with anything else, because they have the ultimate power to make laws that will be with us forever. And once those laws are in the books of the Supreme Court decisions, it makes very little difference what subsequent administrations do, because they cannot be in conflict with what the Supreme Court has decided. So
Yeah.
I hate to take your hope away, but I'm pretty pessimistic in that arena. But we'll see.
Okay. Well, Kathy, thank you so much. And as
Thanks for
Toby
inviting.
said, you are such an asset to our online and to the state board. And wow, wow.
Thanks,
All
Kathy.
right.
Thanks for giving
We're
me the opportunity.
okay. I think we better say goodnight. We
Yep.
didn't lose anybody,
I'm
which
going to
is
stop the
really
recording
good.
now just to be stopping now.
Okay. All right.